and truly answer all questions pertaining to your qualifications to serve as jurors in the case now pending?
Okay, ladies and gentlemen, have a seat. We are going to call up 24 of you at your box. So when you get your number called, the first person can sit in the back row of the box, the farthest seat to my left, fill in 7, and then we'll just go row after row, again filling in from the left to the right.
Number 2929. 215, 215. 212, 212. 207, 207. 179, 179. 44. 58, 58. 142, 142. 62, 62. 108, 108. 252, 252. 80, 80. 74, 74. 121, 121. 24, 24. 21, 21. 193, 193. 140, 140. 274, 274. 297, 297. 83, 83. 214, 214. 119, 119. 318, 318.
319, in jury box.
Before we begin, is anybody have any cell phones on them? Great. Ladies and gentlemen, we are selecting a trial jury for the criminal case of State of Oregon versus Kennedy Sherrill Walker. And the state is represented by Mr. Henninger, who is seated to my right, and then Mr. Walker is seated at the council table to my left. The defendant is charged with the following two offenses. Count 1, attempted unlawful delivery of a Schedule I controlled substance. Count 2, unlawful possession of a Schedule I controlled substance. Count 1 alleges as follows. The defendant, Kennedy Sherrill Walker, on or about August 26, 2023, in Marion County, Oregon, did unlawfully and intentionally attempt to deliver psilocybin, a Schedule I controlled substance. Count 2 alleges as follows. The defendant, Kennedy Sherrill Walker, on or about August 26, 2023, in Marion County, Oregon, did unlawfully knowingly possess psilocybin, a Schedule I controlled substance. To these offenses, the defendant has entered a plea of not guilty. A plea of not guilty is now every offense. Under our system of justice, the defendant is presumed innocent of any crime or wrongdoing unless and until the state proves the defendant's guilt beyond a reasonable doubt. Therefore, the burden is on the state to prove the defendant's guilt beyond a reasonable doubt. Some people may serve as jurors in civil cases where lesser standards of proof apply. For example, proof by a preponderance of the evidence or proof by clear and convincing evidence. In a criminal case, however, the state's proof must be more convincing. It must be beyond reasonable doubt. Reasonable doubt is doubt based on common sense and reason. Reasonable doubt is an honest uncertainty as to the guilt of the defendant. A reasonable doubt exists when, after careful and partial consideration of all the evidence, we are not convinced beyond a reasonable doubt. Each juror must be able to judge this case fairly objectively. Therefore, any juror knows of, or is any association with parties, lawyers, or witnesses, or if any juror has his own knowledge or has formed any opinion about this case, this should be brought to the court's attention. First, by raising hands, do any of the jurors know either Mr. Henninger or Mr. Kennedy? Okay. And then juror number 119, who do you know, sir?
I know both parties. As your Honor knows, I'm Deputy District Attorney and I've worked with Mr. Henninger for years. I also know Mr. Walker. In some of the hearings leading up to this trial, when Mr. Henninger wasn't available, I appeared in the state's position. As such, I've reviewed some of the evidence, heard legal arguments. I cannot be fair and impartial under those circumstances, and that has to be dismissed.
Okay. Do either party oppose me excusing juror 119?
No.
No. Okay. So juror 119, you're excused. If you leave your button at the door, or competition.
173, 173.
Juror 173, do you know either of the parties? No. Okay. And then, do any of you have, next I'm going to ask the parties to list the potential witnesses and then ask if you know them. Mr. Henninger?
Yes. State intends to call the Ontario Police Department John Esplin, Rick Reyna, and also Terry Ann Finnerty.
And then, Mr. Kennedy, do you have any witnesses?
No.
Okay. By raise of hands, do any of the jurors know any of the witnesses? Oh, 3 hands. Okay. 3 hands, and I'll try to get to you one at a time. Juror 142, who do you know, sir?
Mr. Reyna, Mr. Esplin.
Okay. How do you know that?
Grew up with them, coached them.
So I'm going to ask a question that's going to be asked a lot, so I want to give some examples. The question is your knowledge of the person or a fact that can affect your ability to be fair and impartial. We just want everybody to start at the same starting line of this trial. If you know somebody or know something about the case that you think that can give us a head start, or maybe put some behind the starting line, then obviously we don't want that. So with that in mind, the thoughts you may have regarding that year 142, your knowledge of the person individual can affect your ability to be fair and impartial.
Yes, I believe so, sir.
Yeah, just throw it out with them.
Yeah, and coaching them going a whole lot.
Just before you say, you wouldn't be able to be fair? Is that what I'm hearing?
Well, I hope. I mean, they're friends, not just
Any objection to me excusing juror 142?
No.
Okay, 142 shall be excused. Or vice chair.
$277, 277.
277, do you know either?
No.
Do you know any of the witnesses that were listening? No. Okay, great. I think juror number, is it 80? Did you have your hands raised, sir? Oh, okay. There is someone else? Oh, you, okay. Juror 121.
Mr. Ray, Mr. Espo.
How do you know that?
I grew up in town there.
Any about knowledge of them going to affect your ability to find motion? And then juror number 193, did you raise your hand?
Yeah.
Okay, who do you know,
I
sir?
know Mr. Reyna, he worked at Les Schwab, but it won't affect.
Won't affect your ability to find motion. And there's someone in the okay, juror number 297, do you know that?
Terry Ann Kennedy, but only at the Saturday markets.
Anything about that going to affect your ability to find motion? Okay. And then juror number 173, who do you know, sir? Okay, how do you know him?
Just the small community.
Anything about your, whatever limited knowledge of him that's going to affect your ability to find motion?
No.
Okay, great. Mr. Kennedy, is your camera on over there?
Yes.
Okay, you need to turn it off, sir.
Oh, I put in a request. It was approved.
When was it approved by him?
Judge Landis. It was approved September 11th. Motions hearing. It's a public trial anyway.
I understand that, but it doesn't mean it gets recorded. Do you see it?
If you're looking for a motion, it was an application through the court, not a motion. Actually, there wasn't a motion for it, but then the judge told me he wanted it to go through the court instead.
I'll let it on for now. We're going to deal with it in a second. We'll take a recess. Okay, and then third, do any of you have personal feelings regarding this type of case that would affect your ability to defend motion? Okay, next, we're going to ask you a series of 5 questions. They're on the various screens about you, around you. Question number 1 is what town do you live in? Don't get distracted. It's just Ontario, Vale, Sloan, whatever it may be. Question number 2 is what is your occupation? And if you're retired, what was your occupation prior to retirement? Question number 3 is if you have a spouse, do you have a spouse? You'd like to know what their occupation is or was if they're retired. Question number 4 is if you served on a jury before, and by service we mean you made it past as part of your opening statements, read some evidence, and then at the end of the trial went back and deliberated. If you have served on a jury before, we'd like to know approximately how long your last service was, 2 years ago, 5 years ago, 10 years ago. And then what type of jury was it? Was it a criminal jury, which is the state accusing someone of a crime, a civil jury, which is usually 2 parties fighting about money in one way or another, or a grand jury, which is a special process you know about, served in that. And then question number 5 is do you have any close ties to law enforcement? It's not just friends and acquaintances, but family members, close friends that work in law enforcement. If you do, then we'd like to know how they're related to you, uncle, niece, best friend, whatever it may be. And then what agency you work for, Ontario Police, State Local Correctional Institute, California Highway Patrol, whatever it may be. If you have any close ties to law enforcement. So with that, jury number 29, could you answer those 5 questions?
I live outside of Ontario. I'm a farmer. My wife works for the University of Idaho. I served on a jury during COVID. I don't remember what year, 21, 22. All I know is it was COVID set up in here. It was a criminal case, and I have cousins that work at the state penitentiary here.
Okay, great, thank you. Jury number 215.
I live in Vale. I'm a deputy clerk. I'm divorced. I served on a trial 25 years ago, and I don't remember. It was domestic violence. So other than that, and I did have a grandfather that was a chief of police down in Canby, but that was back in before 1980.
Thank you. Jury number 212.
I live near Adrian. I work work for an irrigation company, a weed specialist. Been married. Wife works for Niagara County Jail.
Yeah, was in the 90s, last time I was on a jury, was criminal. Ties is the wife working here to do.
Great. Jury number 207.
I live in Ontario. I'm self-employed. I'm a business coach and life coach and tax prep. My husband works for Stevenson County. I served about 8 years ago on a criminal case, and I have no ties to law enforcement.
Great. Thank you. Juror 179.
I live outside of Ontario. I'm a registered nurse. My husband is a retired farmer. I served about probably 30 years ago on a criminal trial, and I do not have any ties to law.
Okay. Thank you. Juror 44.
I live in Ontario. I work at community college. I'm not married. I served on a jury about 10 years or more. It was a criminal case. And my cousin was a police officer in Portland.
Great. Thank you. Juror 58.
I live in Ontario, and I'm a retired teacher. My husband is an attorney. I served on 2 juries before, both criminal, probably 25 years ago, and no ties to law enforcement.
Great. I'm going to jump in front of you here. Juror 121.
I live in Nissa. I'm a general contractor. I'm not married. I served on a jury about 4 or 5 years ago. It was a criminal case, and I don't have any ties to law enforcement other than back home.
Juror 74.
I live in Nissa. I'm secretary for the Hilltop Memorial Cemetery. My husband works at the Outdoorsman. I was on a criminal jury about 20 years ago, and no ties.
Juror 80.
I live in Nissa. I am a registered nurse. My wife's stay-at-home mom. Never been on a jury. I have a cousin who's in the Idaho Highway Patrol for state.
Thank you. Juror 252.
I live in Ontario. I'm retired. I was a former SRCI officer. I'm married. My husband just retired from law enforcement after 30 years. Never served on a jury before. And law enforcement, my husband.
Okay. Great. Thank you. Juror 108.
I live in Ontario. I'm a pharmacist. My husband farms. Never been on a jury. And
Great. Juror 62.
I live by Adrian, and I don't work anymore. I'm married to a farmer. I have never been on a jury, and I have no ties with law enforcement.
Okay. Thank you. Juror 277.
I live here in Bell, head mechanic. Married, my wife works, she's the office manager at the dentist office. I served on a jury 2 or 3 years ago, and then about 15 years ago I was on the grand jury. And then I got cousins that are state police in Portland, Salem area, and then I have a brother-in-law that works here in the jail.
Great. We'll skip that ahead in front of you. Juror 24.
I live in Vale. I'm retired. I work for the city of Ontario. I was a water quality lab technician for 20 years. My wife's retired. She was the Malheur Watershed Council grant writer for the Malheur Watershed Council. I served on a jury probably 10 years ago. It was a criminal, and I don't know anybody that's a cop or anything, so.
Okay, great. Juror 21.
I live in Ontario. I used to work construction. I'm not married. I was on a grand jury about 10 years ago, and I don't have any ties.
Juror 193.
I live in Ontario, and I help manage an onion processing plant in Defendant, Idaho. My wife is a educational assistant at the Malheur ESD. I've never been on a jury before, and I don't have any ties to the law enforcement.
Juror 140.
I live in Vail. I am a stay-at-home mom, and my husband works at the Mount Airy County Sheriff's Office in the dispatch. And I've never served on a jury, and my husband was deputized a lot.
Thank you. Juror 274.
Outside of Ontario, mechanic, not married. I've served grand jury twice. I'm retired as well.
Yeah, I'll skip ahead in front of you. Juror 318.
I live outside of Vail. I'm retired. Past occupation was global seed production specialist. I am married. My husband was a seed processing specialist. Have you served on jury before? No. Do you have any ties to law enforcement? No.
Great, thank you. Juror 173.
Nissa. I gamble for a living, self-employed. Yes, I am married. My wife's a nurse. I've never served on a jury, and my father is a law enforcement officer.
Great, thank you. Juror 214.
I live in Ontario. I'm a cleaning technician. I'm not married. I have not served on a jury. And I have a couple of cousins that work for the NIPA Police Department.
Thank you. Juror 83.
I live in Ontario. I'm a veterinary assistant. I'm not married. I've never served on a jury. And my best friend is a Mount Airy County dispatcher.
Thank you. Juror 297.
I live in Ontario. I'm a retired registered nurse. I'm married. My husband claims to be retired, but he's still working. He works as the curator for the Japanese garden. I served on the grand jury here, I think, in 2018, and I have no ties to law enforcement.
Great, thank you. The parties will now ask each of you questions. The purpose of these questions is not to embarrass you, but to determine your qualifications for this specific trial. Mr. Kennedy? Mr. Walker?
Okay, is this to everyone, or am I asking specific?
You can direct questions at the entire panel, or you can direct questions at a specific member you wish.
Okay. To the entire panel, then, have you been threatened to appear for jury service by the state? Did they make a threat of contempt of court against you in order to compel you to be here? And can we go through and get everyone's answer?
You can ask it. I'm going to let you direct it how you want it. If you want to.
Could we just start at 29 and do the same, and go through it the same as how the judge just went through it? So 29, is that you?
Yeah.
Have you been threatened to serve on a jury today with contempt of court?
I think there's something on the paper, but I don't recall. It's just a civil duty. You sign up when you...
So could we limit these to yes or no answers?
I'm not here. I'm allowing you, if you want to ask Juror 29, could you answer yes or no? Then I'm not part of this. This is you and the jury.
Okay. Could you just answer yes or no?
No, I don't consider it a threat.
Okay, you weren't threatened with contempt of court?
No, I don't consider that a threat.
Okay. 215?
I don't consider that a threat, no.
Okay. Jail time is not that's not a threat? Okay. 212, have you been threatened? Okay. So they didn't send you a flyer saying if you didn't show up, you'd be charged with contempt of court?
I don't feel that's a threat.
I'm sorry?
I don't feel that that's a threat.
207?
It was stated that I don't feel threatened by this meeting.
So the answer is yes, you were threatened?
It was stated, but I don't feel threatened. So if you're going with
Okay.
feeling, no.
I see. 179? You weren't threatened to be here? Not even with contempt of court?
I read it in a brochure.
A brochure. Is that the jury flyer that you were sent? Where did the brochure come from?
I've read it.
I'm sorry, could you repeat that?
I have read it and I don't look at it.
Okay. 44? You weren't threatened?
No.
Okay. 58?
No.
Okay. 142?
No. Oh, no.
I'm sorry?
Sorry. I'm 177, or 277.
Oh, you're 277? Okay. I have a hard time writing, so
142 is excused and 277.
I understand. 62, were you threatened to be here? Okay. 108?
No.
252?
No.
80?
No.
74?
No.
Were these people sent a flyer that threatened contempt of court? The answer is on the flyer. Can we get this flyer?
This is a chance for the board there, Mr. Walker. Why don't you focus on that?
Okay. Let's see. Sorry, am I at 80?
I said no.
Okay. 74, were you threatened to be here? 121, were you threatened to be here with contempt of court?
No, it didn't say anything on the postcard about contempt of court.
Okay. 24?
No.
You weren't threatened either. 21, were you threatened? No. 193?
No.
140?
No.
274?
No.
297?
Oh, no.
And then 83?
No.
And then I'm sorry, I don't know what your number is. It's not 214?
214.
Oh, it is 214, and yours is something else. Okay, were you threatened?
No.
Okay, 119? Sorry, what was your number?
173.
173. Were you threatened to be here?
No.
And 318, were you threatened to be here?
No.
Okay. So, Your Honor, I was threatened when I served on a jury 2 years ago here that if I didn't show up, then I would be held in contempt of court. Now, I find that disturbing because it's the state that's bringing these charges against me. And so, if the state is threatening my jurors, then I need to know about it, and I think that we need that document that was sent out to each of these jurors.
Mr. Walker, this is time for you to question the jury. So please take this opportunity so we can keep this trial moving along.
Okay. All right, let's start at the beginning then. Juror 29, if the federal government creates a law that violates, if the federal or state government creates a law that violates any federally protected rights, then does that law apply?
The laws apply to everybody, otherwise you'd have a breakdown of civilization.
I'm asking specifically about something that violates a law of the United States. So say a law of the United States, like you have a right to, say, freedom of press. And yet when I come into court, people are saying, hey, you can't record. Then what I'm asking you is it lawful to uphold a law that violates a constitutional principle?
If it's been passed into law, it doesn't. If it's been passed into law, it applies to everybody. So if it's a law, everybody follows it. It doesn't matter if you don't think it's constitutional, you still have to follow it. Otherwise, you get a breakdown in civil society.
And
okay, we're outside the presence of the jury. So, Mr. Walker, I'm telling you because Mr. Hanger is already aware of this process. There are, that list we gave you, there are 24 jurors. You will get the first strike. That means any jury you want to strike, you can let me know who that is. You can tell me that strike by either the juror number or the jury seat. As you can see on that sheet, we have this juror number 1 and then their actual number. So either one of those. Mr. Henninger will get the next strike, and we'll go back and forth. Each party will get 6 strikes, and then at the end of that, there will be 12 jurors left, and those will be the final 12 jurors. So, Mr. Walker, who's your first strike?
How many did you say?
You're going to get a total of 6, but you're not going to, we're going to rotate. So you take 1, they take 1, and then each of you will get 6 each, which means there'll be 12 stricken total. And that, and since there's 24 jurors before you, that will leave 12. So you have a jury of 12 people at the end.
Okay, 215.
Okay, so let's see. Seat number 2, juror 215 is defense 1.
I'll do seat 6, juror 44.
Seat 6, juror 44 is plaintiff's 1.
Do 21.
Could you say that again?
21, that's, I believe, juror number 16.
Okay, seat 16, juror 21, thank you. That is defense 2.
Juror 207, which is seat 4.
Okay, seat 4, juror 207 is plaintiff's 2.
140.
Okay, 140, seat 18 is defense 3.
I'll do seat 7, juror 58.
Okay, seat 7, juror 58 is plaintiff's 3.
$274.
Okay, 274, seat 19 is defense 4.
Juror 24, seat 15.
Seat 15, juror 24 is plaintiff's 4.
Let's see, there's what, 2 left?
You get 2 more strikes. The state gets 2 more strikes.
$252, juror 11.
Okay, seat 11, juror 252 is defense 5.
62, seat 9.
Seat 9, juror 62 is plaintiff's 5.
$74.
Okay, seat 13, juror 74 is defense 6.
I'll just strike the last seat.
Okay, seat 24, juror 17 is plaintiff's 6. So what we have remaining is seat 1, juror 294, seat 3, juror 212, seat 8, juror 277. Oh, I'm sorry, I missed one. Seat 5, juror 237, then seat 8, juror 277, seat 10, juror 108, seat 12, juror 80, seat 14, juror 121, seat 17, juror 193, seat 20, juror 297, seat 21, juror 83, seat 22, juror 214, and seat 23, juror 173. We have 12 jurors. I'll give you guys a recess too. And so I told jurors to be back here at 4 until so you have about a 6-minute recess. And obviously the jurors that don't need to stay. there. If everybody can get out, all groups that would get out. And then the 12 people that aren't staying, please move to the back, have a seat in the back. The 12 people that are staying, please come back and sit in the seats so I can make sure I have 12. There is no assigned seating. We'll be removing these chairs, but otherwise you can stay anywhere you want in the box. You don't have to stay in the same seat throughout the trial or whatever procedure is most common. Yes. So again, if I call your number, you are presiding over this case. Juror 294, Juror 212, Juror 237, Juror 277, Juror 108, Juror 80, Juror 121, Juror 193, Juror 297, Juror 83, Juror 214, Juror 173. Yeah, when I called your number, you're the children of the case. Let's try to make the exchange the best we can. The rest of you, thank you for your service today. If you can leave your buttons by the door, have a wonderful day. Just a minute here, I'm going to excuse you to the jury room, and we're going to take our lunchtime recess. I'll ask them to be back at 2 o'clock in that jury room, so hopefully you guys can have some plans for a couple hours. I'm going to excuse you to there. My staff's going to talk to you just about what's happening, some logistics and stuff like that. Usually, I would tell you that we wouldn't usually be going to right to lunch hour at this point, but if you need us to call anybody, any employer, family, whatever, to let them know that you're on jury service for today and tomorrow, then please, we can do that for you. Just ask my staff. But since I'm excusing you, you can also just use your own phone if that's easier. But again, if you have an employer that wants to hear a voice from the court, then we can do that for you. In that room, when we come back at 2, there's bathrooms in there, there's snacks in there, there's drinks in there, stuff for your comfort. There's also notebooks in there. If you process information by taking notes, you're welcome to bring a notebook out with you to the courtroom and take notes. You don't have to take notes, but some people need to take notes to process information. The notebook cannot go with you, basically. It's either here or the courtroom. My staff will take care of it if you're not here. Other than that, yeah, if you have any questions from my staff, then that's great. They'll come in there just a few minutes after you and answer any of those questions. We do expect this to be a 2-day trial, so we'll make arrangements there. The current schedule is to go from 9 to noon and 2 to 5 every day, so we'll get a 2-hour break in the middle of the day. We'll start a little bit later in the morning, so again, 9 to noon, 2 to 5 again. Make arrangements with whatever you need to do, if you do family or others. So with that, then come back at 2 o'clock. When you come back at 2 o'clock, I'm going to read you what's called the precautionary opening jury instructions, and then after that, we'll hear opening statements, and I presume we'll hear at least one witness today, maybe more. But again, we'll end at 5 o'clock. Again, we'll see you at jury room. time recess, we'll resume at 2 o'clock. Thank you.
Your Honor,
Yes.
not doing very good, very well right now, and I just ask for modification to the court hours so that I can have some recovery time between.
They're not out there, correct? They're not out there. They're still, nobody's, can we keep them in there just for a second?
They're being let out. You're going to call back until they get too far?
No, this is, okay. What I am willing to do today, just since we do have a 2-day trial, again, I made a decision earlier, I understand your medical needs. How about we start at 2 o'clock? We'll do the precautionary jury instructions and the opening statements. Since the jury's already coming back, that I imagine will take an hour. I don't know, maybe an hour and a half, depending how long the opening statements are. But then not taking our first witness to tomorrow, that means we can end early today instead of going all the way to 5 o'clock. Would that be beneficial to you, Mr. Walker? Can you say something?
Yes.
Okay, I can hear you. I can see you nod, but I just wanted to make sure that that's on the record. Okay, so let's do that for your benefit, Mr. Walker.
Is there a way that we could do that now?
No, the jury's already gone. The other option, you have a constitutional, I'm not trying to tell you how to run this. You have a constitutional right to be here for trial and everything else, but since we're just doing opening statements, your right to be here in large part is to confront any witnesses. Since we won't be taking any witnesses today, I'll give you the option. You'll need to be here in person tomorrow, but I'll give you the option for today. If you want to appear by video or telephone, we can set those up for you just to do, again, jury instructions and your opening statements.
Yes.
Is that something you want?
Yeah, that would help.
Okay. So can you tell me, just so my staff can be ready, are you planning on calling in at 2 o'clock? Is that correct?
Yes.
Okay. Okay. And that's just so I know my staff, let them know that you should receive a call. And then, so we will do precautionary jury instructions and opening statements at 2 o'clock, and then we'll conclude for the day. I'm sure it's a 2-day trial no matter what, and I'm sure some of the juries will actually be happy if that happens. So, and then I do need to let you know, we've checked our records. We had Judge Landis listen to the hearing on September 11th, and there has been no such order to grant recordings, so I'm going to instruct you not to record the proceedings. I needed to check those things. I didn't want to challenge you at the beginning, but that order has not been given. So you'll need to turn off the camera this afternoon. You won't be here, so I won't be camera. But the rest of the proceedings, no cameras in the court. Okay.
So, couldn't I just file another?
The rules require that you file it before the proceedings, and we don't have any notice of any such filings before the trial. So.
Well, then it must have happened on a different day or something.
Well, why don't you check your records? If you think there is an order on a different day, then we can check that also. But we base it off any filings prior to September 11th, and then we also listened to the September 11th hearing. So that's the date you gave us. So that's the date we checked. I'm trying to get you out of here, mister, so you can have your rest. So
I'm just trying to figure out what it is you're saying. Judge Landis approved recording. If it wasn't on September 11th, then it would be... It was on September 11th, I think, but...
Okay.
He definitely approved it. I mean, you're trying to keep records from me again. Look, if I had a record of the September 11th hearing, then I could show it to you, but I've requested those records and I can't get them. So the only record that exists is what you have, so there's no one else to say otherwise because I was prevented from recording, which is right.
Okay. Well, I know you disagree, but I remember when so. Well, we will expect just to confirm, I want to make sure you are comfortable calling at 2. You don't want to be here in person. You're welcome to come back, so you let me know. You're calling at 2 o'clock, correct?
Yeah, I'm calling at 2 o'clock.
Okay, sounds great. See everybody then. Thank you.
Walker?
I don't answer questions.
Huh?
I don't answer questions.
I'm sorry, I can't hear you with the traffic going by.
I don't answer questions. What do you need?
Okay, well, I know that you're Kenneth Walker, and I need you to step out of the vehicle. You're under arrest. You have a warrant for your arrest.
For what? I just left court.
It's an extraditable warrant out of Idaho. And I see you're recording. I'm recording too, just to let you know.
I just barely left court, and I didn't identify.
To our attention.
And you're saying I have a warrant out of Idaho?
Yes, that's what I'm being advised.
So I gotta step out and I'm under arrest? Is that what it is? Let's see, can I call my mom? I know you're not gonna let me use the phone at the jail.
Huh?
Can I call my mom? I know you're not gonna let me use the phone at the jail.
The jail will let you make phone calls.
Let's see, can I speak with your supervisor?
Is there a reason why?
Yeah, I want to know how you got a positive ID on me.
Window only. That, like, when the car's going by, I can't hear you.
How did you get a positive ID on me?
Because I know who you are.
I don't know you. I didn't identify to you. Can I get your supervisor?
I can see if one's available, sure. Are you not going to comply with my lawful orders to step out of your vehicle?
You don't know my identity, do you?
I do. I know you're Kenneth Walker.
I've never met you before, so...
But I know who you are. I know you're Kenneth Walker.
Do you have a warrant with my name on it?
In my possession, no. There is a warrant for your arrest. I'm being advised.
Well, I need to see that warrant before I'm going to submit to a seizure. Dude, I just left court. Why are you bothering me?
He's requesting a supervisor. He's not complying. Step out for me.
Do you have a warrant to seize me?
Yes, there's a warrant for your arrest.
Well, show me it.
Well, in this situation, I don't have to show you the warrant. It'll be provided to you.
Well, you didn't use...
Step out of the vehicle, please.
Who do you want to step out?
Kenneth Walker.
That's not me.
Oh, it's not, huh? So are you going to give me false info?
No, you're giving me false info. I don't know you.
I know you are Kenneth Walker.
I'm not.
Okay, who are you then? I know you're Kenneth Walker.
I'm not. Go ahead and show me a warrant, though, that has my name on it, and then I would comply.
To actually show you the physical warrant, because it'll be provided to you.
Yeah, you have to have a warrant, and it has to have my name on it.
It does have your name.
What's my name?
Kenneth Walker?
No, it isn't.
Okay, what's your name then?
No, I don't answer questions.
You want to step out of the vehicle, please, sir?
No, you don't even know my name.
It's Kenneth Walker.
It's not.
Step out, sir. Like
Who?
I said, you were under arrest for a warrant.
But that's not my name.
Okay, what's your name then?
I don't answer questions. Am I free to go? Am I free to go?
No, you're not free to go.
Why?
I told you you're under arrest.
You are arresting someone named Kenneth Walker.
Okay, then provide your ID then.
I don't need to prove anything to you.
Lawful traffic stop. Your vehicle's not registered.
A seizure.
I know who you are.
Which you need a warrant.
I know your name is Kenneth Walker.
It's not. It's not, dude. I'm telling you.
Well, if your name isn't Kenneth Walker, then provide ID.
I don't need to prove anything. You need to prove you have a right to seize me.
Yes, there's a warrant for your arrest.
Apparently not.
I know who you are.
You apparently don't, because that's not my name.
What's your name then?
I don't answer questions. Am I free to go? Apparently, I have no battery.
Sir.
What?
You are under arrest. I've already stated that.
You don't even know who I am.
Kenneth Walker.
No, I'm not.
What's your name then?
I don't answer questions. Am I free to go?
Huh?
I don't answer questions. Am I free to go?
No, you are not free to go.
Well, what's my name then?
Kenneth Walker.
That's not my name. Well, dude, what is he doing? Please don't get in.
Step out of the vehicle.
Please don't interfere, dude.
Step out of the vehicle.
Please don't interfere.
Step out of the vehicle. Do not resist. Do not resist. Step out. You are under arrest.
Do you have a warrant for me?
Yes.
What's my name?
Kenneth Walker.
That's not my name.
What is it then?
I don't answer questions.
Well, if your name isn't Kenneth Walker, which I know it is.
It's not, I promise.
Provide ID, because this is a lawful traffic stop.
Can I speak to a supervisor? This guy is accusing me of being someone I'm not.
So, as of right now, it's a lawful traffic stop. Failure to provide ID is also a crime in Oregon.
No, that's a seizure. That's a search or a seizure of my identity.
No, it's a lawful traffic stop. You don't have plates in the vehicle.
Stop means seizure.
And he's okay. Step out of the vehicle. Step out.
Hold on, I'm injured.
Nope.
Hold on.
The vehicle.
I'm disabled. Okay. Now hold on.
We're not gonna hurt you.
Well, you're seizing me without a warrant, and you don't know my name. What's my name?
Kenneth Walker.
No, it isn't.
What is it then?
I don't answer questions.
Well, if you're saying your name isn't Kenneth Walker, which I know it is, it'd be simple to prove otherwise if you have a lawful ID saying that it isn't.
I don't need to prove anything to you. You need to prove that you've got a reason to bother me.
You have a warrant for your arrest. I know.
What's my name then?
Kenneth Walker. I'm not.
No, it isn't.
Step up. Come on.
Dude, it's not my name. Hold on a second. That's not my name.
I was just in the courtroom with you. It is your name.
No, it isn't. Let me just see the warrant.
They will provide a copy to you at the jail.
So you're seizing me without a warrant?
No, there's a warrant.
So it's an illegal seizure?
No, it's not. It's a confirmed warrant.
For someone with a different name?
Kenneth Walker is not a different name than you.
That's not my name.
Come on, step up.
Can I speak with the supervisor?
Yeah, when he gets here, but it'll be in the back of my car.
I want to not be seized unless you have a warrant for me.
There is a warrant. I'm not going to keep.
Dude, you don't even know my name. How is there a warrant if you don't even? Hold on a second.
Step up.
I'm hurt.
Then step up.
I'm hurt.
Then I'll help you up. Grab my hand. Come on.
Here, just get out of the way. Jeez.
Keep your hands where we can see them, please.
Yeah, I don't have anything. Okay. All right. I gotta hold on to both.
Do you need assistance?
Just watch out.
Okay.
Oh shit.
Careful.
Can I roll up my window? Oops. Can I roll up my window? I'm not gonna cause you any trouble, dude.
Do it for you.
I'm retarded.
We can do it for you.
No, you don't have access to my house or my car or anything. Oops, sorry.
Okay, this way. Do you have anything on a person that cannot go into jail, like weapons
questions.
of any kind, narcotics, tobacco
I don't
products?
answer any questions.
Okay. Just to let you know, if you do have any of those items,
I don't answer questions, and you don't even have my name.
I'm not asking you something. I'm telling you. I'm informing you of something. Okay. If you have something under your possession that is not allowed in the jail, such as weapons, narcotics, anything like that, tobacco products, it's considered contraband. Okay, right here, sir. Right here. So, you said you're injured and have disability.
I need to speak
Can your
with
hands
the
go behind your back? Without
Why do you
causing
want to put
pain.
my hands behind my
Because you're
back?
under arrest.
No, I'm not.
Yes, you are.
You don't even have my name.
Kenneth Walker.
That's not my name. What? Dude, what is going on with you guys? Jeez.
Okay, so I don't cause you any discomfort to your injuries. I'm gonna place cuffs in front of you.
Did I have
Okay.
problems with my muscles? Yeah.
Okay. So that's why I'm gonna place these in front of you.
Okay.
Okay. And just let you know, I am going to pat you down for weapons.
No, I
It
don't
means of an
submit to
escape.
any
That's fine. You don't have to submit to this.
You don't have a warrant, so I feel like I should have the option of refusing.
There is a warrant.
Look how that's going to slide off. There is not a warrant. You don't even know my name.
Guys, have a seat. You need assistance getting into the vehicle.
I don't know. We'll see. Oh, shit.
Mary Paul 1-8, one in custody. Just let me know if there's a way I can assist you.
Yeah, I don't know.
Would you like us to go on the other side and grab your belt and help slide you in?
No, that didn't work last time.
Is there any way we can help you?
Would a passenger vehicle help? Would that be easier to get into?
Hey, Sergeant.
Yes, sir.
This guy doesn't know my name, and yet he's trying to seize me.
Okay.
Can I see the warrant?
Follow his instructions, okay?
Well,
We'll get it taken care of.
he's not even calling me by my name.
Well, we're not to have this argument here, okay?
Well, I agree. Let's not do any seizures.
Okay, Kenneth.
Unless
Kenneth, we already know. Quit playing this game. I was just in the courtroom with you.
it's not my name.
So were you impersonating somebody in the courtroom?
I don't answer questions.
Okay. We're not to play. Hop on in. Hop in.
What? That's not my name. I'm telling you that, and you're just insisting. Hop in. Let's see if I can hop.
Well, I've asked you how we can assist you. I've asked if a different vehicle would be easier for you. So
why don't you just start leaving people alone for a living?
Okay.
Yeah. Would you, I don't know, pick that up and push it in, I guess?
This leg?
Yeah, push it in so I can...
Got it?
Yeah.
Alrighty. Watch that leg. I don't want to pinch it in the door.
So you're just gonna basically insist that I've got a warrant and you're not gonna show it to me or anything? Is that what it is?
Hold on, let me get it recorded again. Now, please ask your question again.
Can you show me the warrant?
They will provide you a copy with it at the jail.
Well, that's
I don't have
not
copies on.
That's not me though, so you're gonna need to get
600, 649 traffic.
Okay. I was just in the courtroom with you. I know who you are.
Go ahead. Organ plate, Union Victor Charles 354 on a red Pontiac Grand Am.
I need a drink. No, my mom will come and pick it up.
Is it insured?
Why are you guys trying to steal my shit all the time?
I'm trying to steal your stuff.
Whose vehicle are you even trying to tow?
If there's insurance, it's okay right here, but it's not a licensed vehicle.
If there's a warrant to seize it, then you can seize it.
I'll be clear.
Okay.
Don't tow my vehicle.
39.
Dude, what have I done to anyone ever? You guys are ridiculous.
Alrighty. Thank you. Yep.
Who's your warrant for?
Okay, Kenneth.
Oh, geez, dude. Can we put the air on? I'm freaking sweating back here. Could you put the air on?
I turned on the vents.
Oh, I don't feel anything.
Fireball 0. Can you quest over the vehicle?
Huh.
Confirm you want a non-presence tow. Affirmative, this is right inbound.
You pretty proud of yourself? Attacking the disabled or what? Is that why I'm under arrest? Is because I'm disabled or?
1241.
Don't pull the disability card with me. I'm disabled. I have a prosthetic leg, so.
Oh, so you're just defrauding disability?
I'm missing a leg.
Oh, really? So you seem able to work to me?
Yeah, I am able to work.
So then you're not disabled? Are you pretty proud of yourself or what?
Yes, I'm proud of my job.
For what? What? How are you helping anyone?
I serve the community.
By running around attacking people?
I didn't attack you.
Dude, you seized me.
You have a warrant for your arrest.
You don't even know my name.
Yes, I do.
What is it then?
Clear.
What is my name?
Kenneth Walker. I was just
No, it isn't.
with you.
Stealing my car. That's scumbag bullshit. Don't you think? Oh, it's fine to just steal my property.
You're still in it.
What are you talking about? You're taking my car, aren't you?
Being impounded.
Oh, you got a different word for it, and so that means it's not stealing. It's all stealing.
Laurel Schaefer out of Chesapeake, Virginia, showing valid no restrictions and one everything.
Can't you just call them and have the warrant sent to your computer? What do you mean, no? So it sounds like you're just trying to interfere with trial, or what? What's the deal there? That's not what's going on?
No, we have a warrant. I don't know how to make that any more clear to you.
It's not clear at all. You don't even know what my name is. So
were you impersonating Kenneth Walker in the courtroom?
No, why the hell would I do that? I need the paramedics to check me out and see if I'm fit to go to jail. Did you hear me?
Yeah, what's going on?
I need the paramedics to check me out. see if I'm fit to go into jail.
What is ailing you so I know what to tell the paramedics?
My physical condition, my handicap.
Okay, so what about that is...
Last time I was in your jail, I almost died. And so...
But that was last time you were there.
Yeah, and now I'm weaker and closer to death's doorway now than ever. So... Can you just get the paramedics there?
Tell me specifically what is ailing you. Like, are you...
My
stroke?
My handicap. No, my physical handicap. I don't want you seizing my car. I consider that theft.
It's not being seized, it's being intended.
That's a seizure.
No, we're not keeping it. It's being towed.
Look, whatever you do with it, if you take it, that's a seizure. This is English, bud.
I'm not going to argue with you.
Obviously. You're just going to spit synonyms at me and tell what you're doing is okay, huh? I'm telling you, you don't even know who you're talking to. No! To me, like you just pulled over an unknown car with an unknown person in it, and then you started accusing them of having a warrant. What's your evidence of this warrant that you have of me? For me? Seriously, just what? What is it? You don't even know my name, so how? What? Yeah, you keep saying that name. That's not my name.
I was up in the courtroom with you, Kenneth.
Yeah, you keep saying that too, and that doesn't change the fact that that's not my name.
Mary Sam, to office.
You turn the AC on? I'm sweating back here.
It's on as high as it'll go. It's on number 7 and 7's high.
Oh, let me guess. That's my fault too.
That makes no sense at all.
You make no sense. You don't even know who the hell I am.
Okay.
Okay, who am I? Okay, wrong. So then, how do you think that you have proof if you don't even know who I am? And don't tell me you were in the courtroom. I don't know why you think that means that I'm someone I'm not. It doesn't mean that. Being in the courtroom with me doesn't... No. Why do you want to arrest people that go to court anyway? Isn't that kind of pointless?
Mary Pollinate at the North Cell, doors are open.
1248.
Here's your phone, I got it up here.
let me out? It's hot in here. Hey, I'm sweating in here. Hey, could you let me out? It's hot in here. And it's gonna be freezing in there. These people are something else.
He has a camera around his wrist. I cuffed him in front. It would cause him any discomfort. Is there any way I can assist you getting out of the vehicle?
No, just hold on.
Okay.
Hey, this guy seized me without knowing my identity, and I don't think that he's got the right person.
We'll work that out with fingerprints, okay?
Why don't you just show me the warrant, and I'll just tell you if it's me or not.
They're going to get you a copy of it.
Yeah.
Okay.
I can't do it. Yeah, I got it.
You got it?
All right, closing the door.
I need a wheelchair.
Okay. We'll get you that after we get in here. If we need to wheel you somewhere.
Honestly, it would help if I could get one right now.
Well, we'll get you in here because you're going to have to be on your feet while I pat you down. So take your time if you need to.
Could you just pat me down right here and get me a wheelchair? I've already been working my ass off, so I'm not doing great. Can we do it right here?
No, we have to be inside our secure facility during the pat down. Take your time.
Turn my hands up.
Take your time.
Also, I need a medical to make sure I'm good to, that I'm fit.
Okay, we're going to come just right to here. Okay, go ahead and put your back, and you can lift your back up against the wall. Do you have any tobacco items on your person?
I don't answer questions.
So let me just tell you that if I find anything on your person that can't come inside of jail, tobacco, knives, guns, needles, drugs of any kind, including marijuana, lighters, vapes, will be introduction of contraband, C felony. Is there anything on your person that you would like to declare now to where the deputy that brought you in can dispose of it?
Oh, I don't know. I need to sit down though.
Okay. So I'm going to take that as a no, so hopefully we don't find nothing, okay?
Hold on.
Hold on what?
I can't work my hands.
Oh, okay. Bring your hands away from your body so I can get to the keyhole on the handcuffs, okay? Okay, once I take your hand out, place it on top of your head.
2, explanation in general, that is what I'm doing now. 3, opening statements. This is when the attorney summarizes what they expect the evidence to be. This is when the parties summarize what they expect the evidence to be. 4, presentation of the evidence. This is when witnesses and exhibits are presented. 5, jury instructions. This is when the judge explains the law that applies to this particular case. This includes explaining what the state must prove beyond a reasonable doubt for a guilty verdict. You'll receive a printed copy of the instructions. 6, closing arguments. This is when the attorneys have opportunity to persuade you how to decide the case. 7, deliberations. This is when you go back to your jury room and decide whether the defendant is not guilty or guilty. 8, return a verdict. This is when you tell us your verdict. You have 2 major roles in this process. First, determine based on the evidence what really happened. We call this deciding facts. The second major role consists of deciding if, in the light of the laws I explained to you, what you decide the facts are, the defendant is guilty of a crime. In performing your roles, you must of course be fair and impartial. You must follow the law whether you agree with it completely or not. You must not allow yourself to be influenced at all by personal feelings, sympathy for, or prejudice against anyone involved in the case. I'll explain in a moment what is and what is not evidence. It is extremely important that you consider only evidence in deciding facts. As a judge, I'm the gatekeeper regarding evidence. I determine what the law allows to be evidence. In effect, the law considers anything that is not evidence to be unreliable. That is why you may not consider non-evidence in deciding facts. However, the law does not conclude that anything that is evidence is necessarily reliable. Determining the reliability or believability of evidence is ultimately your responsibility. You must decide what evidence is believable and how believable and persuasive a particular piece of evidence is. So you are not allowed to consider anything that is not evidence in deciding the facts. You are free to decide how believable or unbelievable, important or unimportant any particular piece of evidence is in deciding the facts. Evidence consists of testimony of witnesses, exhibits that are admitted into evidence. Testimony is what a witness who is sworn or affirmed to answer questions truthfully says about the examined as a witness. Exhibits are physical objects such as photographs, charts, and letters. You'll be able to examine admitted exhibits during deliberations. You may draw reasonable inferences from the evidence, but do not guess or speculate. In understanding what is evidence, it's helpful to have some examples of what is not evidence. The fact that a criminal charge has been filed against the defendant is not evidence. Any defense innocent of any crime unless and until the state proves his or her guilt beyond a reasonable doubt. Questions from lawyers and other non-witnesses for that matter are not evidence. So whenever I sustain an objection to a question, do not speculate about why the question was asked or what the answer would have been. This is a subtle but important point. In our everyday lives, a friend asks us if we've seen our mutual friend's new car. We infer from the question that the mutual friend has a new car. However, it's not the same in trial. The person asking the question is not a witness, is not subject to a safeguards that the law requires before you may consider the person's words as evidence. So in court, you are not allowed to consider questions asked by attorneys or non-witnesses in determining what the facts are. Those questions are not evidence. Of course, when a witness answers a question, you may consider the answer in the context of the question. For example, if a lawyer asks, was the traffic light red or green, and the witness answers green, you may take the answer stating the traffic light was green. However, the witness answers there was no traffic light, you may not take the question as evidence that there was a traffic light. From time to time, a lawyer may object to something that's offered as evidence. I'll decide whether the objected to material will be admitted into evidence. If I overrule the objection, the material, for example, an exhibit or a witness's answer to the question becomes evidence. If I sustain the objection, the exhibit is not admitted as not evidence, or the witness is not allowed to answer the question. If the witness starts to answer a question before I sustain an objection to the question, you must disregard the witness's response because the response is not evidence. Occasionally, I may decide something that has been admitted that evidence should not happen. If that happens, I'll instruct you to disregard the exhibit or testimony that should not have been admitted. This means that the material is no longer evidence. You must not consider it anyway. You must treat it as if the question had not been answered, the exhibit had not been received in the first place. You must not interpret a statement, ruling, or remark I made during this trial as any indication or form any opinion about the facts or outcome of this case. You and you alone are to decide the facts. You must decide how believable the evidence is and what weight or value you give that evidence. During a trial, you'll be allowed to ask questions of witnesses. If you have any questions of a witness, you'll submit them in writing. The procedure for submitting questions is as follows. Please wait until the end of the witness's testimony because the question may be answered by the time the lawyers are through. You may write your question down, fold it, and hold the paper to get my attention, or you may raise your hand and I'll wait for you to write out your question if you've not already done so. The clerk will get the question from you. Your questions are subject to the rules of evidence, just as the lawyer's questions are. I'll review the questions with the lawyers and we'll rule on whether the question may be asked. I'll be the person to ask the question of the witness if I decide it's proper. We do not expect jurors to know fine points of asking questions pursuant to the rules of evidence. Accordingly, they may sometimes modify questions so that it conforms to the rules of evidence. If the question is not asked, jurors should not draw any inferences about my ruling or speculate as to what the answer to the question might have been. Do not weigh answers to juror questions any differently than any other answer simply because the answer is given in response to a juror question. After any juror questions, the lawyers are allowed to ask follow-up questions. You may take notes if you wish during trial. However, please keep in mind that each party is entitled to consider the decision of each jury. Therefore, during deliberation, you should not give undue weight to another juror's notes if those notes conflict with your notes or your recollection of the evidence. Do not allow your note-taking to interfere with your ability to observe and evaluate testimony. Your notes may be in two places, the courtroom and the jury room. You may not take notes with you on lunch or overnight breaks, for example. My staff will make sure that your notes are safe and that no one has access to them in your absence. Do not discuss this case during the trial with anyone, including the lawyers, parties, witnesses, your friends, or members of your family. This includes not communicating anyone by any other means, such as telephone, text messages, email, internet chat, blogs, or social networking websites. Do not discuss this case with other jurors or look at other jurors' notes until you begin your deliberations at the end of the case, after you have heard all the evidence, arguments, the lawyers, and instruct on the law that applies to this case. Each of you must be able to keep an open mind throughout the trial and must not attempt to decide this case until you begin your deliberations. Do not make any independent personal investigation into facts or locations connected with this case. Do not look up any information from any source. Do not communicate any private or special knowledge about any of the facts of this particular case to your fellow jurors. Decide the case only on the evidence received here in court. Do not read any news stories, listen to any radio or television reports, or read or listen to anything on the internet about this case or anyone involved in the case. In addition to conventional research, you must also not use any internet search engines such as Google to look for any information about the case, the law that applies to the case, and the people involved in the case, including the defendant, the witnesses, and the lawyers. Do not use any map programs or mapping systems to attempt to review it or locate any locations that may be discussed in this case. In short, do not communicate to anyone by any means concerning what you see or hear in the courtroom, and do not try to find out more about this case by any means other than what you learn in the courtroom. Decide the case only on what happens here in open court, where both the state and the defense are aware of the opportunity to question the sources of evidence and to address any legal issues that may arise. That is the only fair way to decide a case. If you base your verdict on anything other than what you learned in the courtroom, that can be grounds for the mistrial, which means that all the work that you, your fellow jurors, parties, lawyers, and the judge want to be done all over again. That is why it's so important. Ignore any attempt at proper communication. If any person tries to communicate with you about the case, tell that person you cannot discuss the case because you're a juror. If that person persists, simply walk away and report the incident to the court. You may not talk to anyone about this case, even the people closest to you, except you say that you're a juror in a criminal case, and the judge says you can't talk about it. After you have rendered your verdict or otherwise been discharged from it, you'll be free to do any research you choose or share experiences with anyone you choose, either directly or through your favorite electronic means. We will now hear the opening statements in which the parties will outline the evidence as they expect it to be. After the opening statements, the evidence will be presented. At the conclusion of the evidence, I will instruct you on the law that applies to this case. The lawyers will then make their closing arguments to you and you'll begin your deliberations. At the end of the trial, you'll have to make a decision based on what you recall the evidence. You would not have a written transcript to consult. I will urge you to pay close attention to the testimony as it's given. If any time you cannot hear a question or answer, let me know immediately by raising your hand. Senator?
Thank you, So we're going to go back to 2023, Saturday, August 26th. In Ontario, you may or may not be aware, they do a farmer's market in the summertime. People from the community can rent a table or a canopy section and sell produce, breads, crafts, things along those lines. You'll hear from Terry Finnerty, who organizes the farmer's market. She's going to let you know that on this particular Saturday, before things kind of got up and going, with customers showing up, people are setting up the booths. The defendant approaches her and asks her if she runs the place, asks her if he can sell his magic mushroom. And it's a back and forth exchange between the two, and she clarifies magic mushrooms, and it comes out that it's psilocybin. And she lets him know that, no, you can't do that here. She'll also tells him that you're free to go anywhere else you want and try to sell them, but not here at the market. You need to fill out a form, pay a fee, and to get a booth like everybody else. So it's a brief exchange, and he does walk away. She'll testify that she does see him approaching people, trying to peddle his magic mushrooms to them. Law enforcement are alerted shortly around this time. And you'll hear from Sergeant John Espelon, who's since retired, but at the time he was a sergeant with the Ontario Police Department. He'll tell you about his exchange with him. First, he'll tell you about what the evidence he sees. And he sees the defendant sitting near a white Dodge Neon with a for sale sign on it. And and the for sale sign has written in marker, magic mushrooms. He'll testify that in the car, he can see a bag, like a grocery bag from Walmart or Albertsons or something like that. And inside that bag is Ziploc baggies of mushrooms. And you'll see a picture of that as well. He'll talk to you about his exchange he had with the defendant. All of this is recorded. I will show you today, instead of the hour or so that they were there, I'll show you about 5 minutes, which goes over some of the pertinent parts of the interactions. The defendant does make comments, they're interfering with my business, things along those lines, which show an intent, and other things as well. I don't believe I will call Rick Rainey today. I think that will be the presentation evidence. You'll see a photograph, a few video clips, and hear testimony from those two people. Thank you.
So on to community statements.
This case is about justice, constitutional protections, and the abuse of power by a system that no longer respects its own laws. The government has the burden of proof, and they cannot meet that burden in this case. Corpus delicti it's Latin, it's an ancient principle of how we determine what a crime is. And what it means is the body of the crime. So if we see a body that's been killed, we can maybe assume there might have been a murder. Well, the same can't be said for property crimes at all, because there is no injured party. No one can demonstrate harm. We can't even be sure that we're talking about a violation of anyone, because there is no one willing to stand up and say, I'm the victim. The Supremacy Clause, Article 6, ensures that federal protections and rights guaranteed by the Constitution override any state law or policy that conflicts with them. So this has something to do with, every part of this case. The prosecution claims that they've got evidence. Well, I don't have a search warrant for any of these searches that the prosecutor's talking about. We follow a specific order where the judge is required to make a judgment call about whether there's going to be a search. That didn't happen. Any evidence, video or anything else, it's not admissible. It was not seized with a warrant. That warrant needs to come with a sworn statement, and it must include damages so that we can be sure that it's not someone's political belief or someone's religious belief, but that it is actually a crime that needs to be stopped. If the police are protecting the people, what are they protecting them from if there's no victim? Historically, prohibition's been tried before. It was illegal then. It was overturned then. And it failed because it violated property rights protected by the Fourth Amendment. Persons, houses, papers, effects. The same principle applies here. In America, we have a right to life, liberty, and the pursuit of happiness. Now, you might not notice, but I've got a pretty severe neurological disease. Who is someone else to tell me what my beliefs are on treatment of it when the doctors can't solve it? Why wouldn't I be free to do whatever I want as long as I'm not creating a victim? Now that might all be extraneous, and it might be too much to worry about, because the facts of this case are, it's a property crime. They don't have any property. Someone wants to claim that I had an illegal substance. Why didn't he seize it?